for today. And we've had a loan case that precipitated this. We expect there'll be other questions, so we thought it best that we lay out all the options that the group has regarding Variety Plus and Marlene Belloc and what's transpired there. And so, because it's a complicated situation, and gets more so probably every day that Scott's been looking at it, I'll start first just by having Joyce tell us what she had, and then we'll move to Scott and let him work into it. So, Joyce?
Okay, the total amount of flood loans was $91,215 for this project. Of that, $68,415 was Category 1 for the building, and $22,800 was 1A for inventory and equipment.
Okay.
And Scott, are you comfortable taking it from there?
Yep, I'll take it from there. As with all of the flood loans, she did give a mortgage. She did have an interest in the property. She also gave security interest to the city in her inventory, equipment, furnishings, fixtures. The real property, however, was subject to a contract for deed. She was the vendee. She was buying it from Witt Real Estate LLC. As I understand it, she was in default to Witt Real Estate, and Witt Real Estate obtained a quitclaim deed from her for that property. Witt Real Estate also had a security agreement and took possession of the inventory, furnishings, fixtures, and then had a sale of that inventory. As I understand it, not all of the inventory was sold. A good portion of it was sold, however, to satisfy the purported debt to Witt Real Estate. Now, I'm saying it's a purported debt for this reason. The only document that I've seen evidencing the debt is the contract for deed. The quitclaim deed preceded the taking possession of and sale of that inventory. It's kind of a complicated legal procedure, but when you take a quitclaim deed, it merges with your contract for deed, and there's no longer a debt. So, in my opinion, he had no right to take possession of the inventory and sell that inventory. There's also questions of whether or not there was sufficient notice in the sale of that inventory. Any security interest that's foreclosed or repossessed needs to be sold in a commercially reasonable manner, which requires notice before the sale. I did see that there was an advertisement posted in the paper the week of the sale. It's generally not considered in the case law that I've reviewed sufficient notice. You know, a lot of times you have to give not less than 2 weeks notice for advertising. There were some other procedural deficiencies. We didn't get notice as a junior lien holder. There needs to be under the UCC a notification of disposition of collateral. That did not occur. We have, however, gotten an accounting, which is what the notification for disposition of collateral entitles junior lien holders to. His interest was superior to that of the city, both in the real estate and in the inventory. But in my opinion, the acceptance of a quitclaim deed for that property terminated the debt or satisfied that debt by legal action. So I think the inventory, it's questionable whether or not the city would be entitled to that inventory. And here's the other thing that I want to know. The city's mortgage on the real property did survive the quitclaim deed. Now, cancellation of the contract for deed, it would not have survived. The city would have been able to pay that current to maintain their interest in the real property, but a quitclaim deed was given, and that had two effects here. First of all, it kept the mortgage valid because it doesn't give any guarantee as to the status of the property. And the second effect that it has is that all of our loans are forgivable based upon maintaining ownership. Now,
Right.
when property is sold, transferred, or otherwise conveyed, there's no longer a forgivable portion of that loan. So the mortgage is valid and is valid for the full amount, without any forgiveness. The difficulties that I see in this, aside from the fact that there is going to, I would imagine that real estate is going to take a different position. I don't know what position Ms. Belloc is going to take. I attempted to contact her attorney last week, and I've been out this week. I hadn't heard back from him as of close of business Thursday. So, she may take the position that she's entitled to that inventory and or the proceeds and perhaps some deficiency because it may have been sold in a commercially unreasonable manner. I don't know that position yet. The problem that the city has is that, as I read her documents, she has not defaulted yet. Her payments don't start until this summer on the 1As, June or July, June. So there hasn't been a default on the city's loan. We don't have a due on sale clause. It's not in any of the loan documents. And so there's no, we can't take action immediately. But with property being sold, obviously, it's something that we need to take some action on. And I think the council's probably going to want your input as to what that action would be. And you're probably going to want mine. So, I'm open for whatever questions you might have. What suggestion would I say we take right now? We got to find out what Ms. Belloc is, what position she's going to take. Because if she can get any of the inventory returned, continue to make payments on the loan, at least as far as it goes with the inventory, to the city of Rushford, that is, that's going to affect our position, obviously.
What about the repayment of the other, meaning, okay, there was a portion here of $68,400 that was, that would have been the forgivable portion, but since that,
Since the property was sold, transferred, or conveyed, it's no longer forgivable.
right, and who do we look towards to pay that now?
Well, the Bellocs are liable on the note.
Yeah.
Okay, but the note is secured by property now owned by Witt Real Estate.
Okay.
So if the Bellocs default, we can go to the property to get repayment. And it end up foreclosing. Now, I will note that ordinarily you see publication in the newspaper for foreclosures. They're on for 6 weeks.
Yeah.
That's under a power of sale clause that banks have in their mortgages. There is no such power of sale clause in our mortgage, which I think is probably ordinary for government units to have to take the extra procedural steps. Banks will sometimes foreclose by action, meaning commence a lawsuit to do the foreclosure, and that allows the banks then to get a deficiency judgment, and we would have to go through that same process, the foreclosure by action, so we'd have to commence a lawsuit against any interest holder in the real estate.
Anyone else have questions?